I've got to move the chair back, sorry. There's too much stuff on one side. You know too.
All good?
Yep, you look amazing.
Thanks.
So you want me here?
Yeah. Right.
Yeah.
Welcome to our lecture on commencing proceedings. One of the important tasks we have as prosecutors is to commence proceedings in court against people by drafting and filing a complaint alleging that a person has committed a particular offence or offences. One of the reasons why this is so important is because there are rules governing Welcome to our lecture on commencing proceedings. One of the important tasks we have as prosecutors is to commence proceedings in court against people by drafting and filing complaints alleging that a person has committed a particular offence or offences. One of the reasons why this is so important is because there are rules governing how complaints can be properly drafted and presented. Failure to comply with these rules can lead to bad outcomes in court, including criticism from defence, from their lawyers, from the magistrates, delays in proceedings, or possibly the failure of those charges. This lecture is going to guide you through the process from the perspective of a prosecutor, and a practical perspective I should say, from the time a file is received at the office up until a complaint is properly filed in court. We'll also briefly consider at the end the power to amend a complaint that's defective once it's been filed in court. As part of the preparation for this lecture, you're asked to read through Part 6 of the Justices Act and Part 2 of the Justices Rules before watching. So if you haven't done that, could I ask you to pause the lecture and go and do that before continuing? Checking the prosecution file. So you're all experienced in completing files as operational police, and you'll be familiar with the various parts of a prosecution file. The first job for us as prosecutors is to check the file. So while operational police and their supervisors will be familiar with some of these requirements, and often files will be of an excellent standard, it's not always the case, and we as prosecutors have an obligation to put our cases properly before the court. So where to start? It might sound obvious, but we need to read the file. It can be tempting to assume that it looks right from a quick flick through of the file once it's received, but until you've read through it and understand exactly what's happened and what the evidence is, it can be extremely difficult to get a handle on exactly what the charges should look like. Simple cases might not take very long. It may be that in a few minutes you can do this and have a very good idea what charges need to be. But in more complex cases, it will take more time for you to decide what the charges should be based upon the evidence. And I need to emphasise one point here. Where you can, you should be looking at the actual evidence on the file. Reading the facts for the prosecutor can be useful to help you understand what a case is about and what some of the evidence should be, but often these documents don't accurately reflect the actual or available evidence in a case. So by looking at the actual evidence on a file, you can properly assess whether proceedings should be commenced. Now that's not to say that files need to be fully completed for us to even start, but there always needs to be sufficient evidence to support an allegation. So if I give you an example of an assault complaint, when you receive the file, you would always expect there to be a statement from the complainant, the victim of the offence, and from other eyewitnesses who saw what happened at the time. You wouldn't necessarily expect to see proofs of evidence from police officers who conducted a video interview with the defendant or who did other matters away from the scene or after the event. They can be attended to later on, and they don't necessarily affect our assessment of whether there's a reasonable prospect of success. But in that context, you can understand why it's important that in assessing whether there is evidence to support a charge, you have to look at what the evidence on the file is and not necessarily just the facts for the prosecutor. What I've done is prepared a list of things that you can look for on a file. I've put that on Milo. It seems like a lot, and it can be. The list's not exhaustive, and I'm sure that there's other things that you can think of that need to be looked at. But you can see the sorts of things that we ought to be picking up. Of course, not every defect or difficulty with a file is fatal to proceedings. and not everything can or needs to be corrected before we proceed. But the more that we can pick up and the better we can have the file prepared, the less problems we have down the track. Okay, so we've read the file. What's next? Having read the file, it's quite possible that you've identified that there's some further evidence that's required, or there's some issues that need to be resolved before we can commence proceedings. Depending on what it is and how much time we have before the matter needs to be in court, for example because of a bail date, or because the statute of limitations might be expiring, you might have sent the file back for further attention, and in some cases you might have sent an email or contacted the investigating officer to ask for that additional information to be forwarded to you. Generally, we will always do what we can to ensure complaints are laid in time for bail dates and before statutes expire, but remember that it's the investigator's responsibility to present the case with sufficient evidence for us to start a prosecution, and it's not our responsibility to commence prosecutions in the absence of that necessary information. So assuming that all of this is done, that you're happy that you've got everything you need, you'll now be looking at the complaint pro forma document, and as experienced police officers you'll all be familiar with the complaint pro forma. This is a document, as you're aware, that indicates what the investigating officer thinks the person should be charged with. What we need to do is reconcile this document with the evidence on the file. That is, for each and every charge on the file, are you satisfied that there exists evidence that, if it was accepted, would satisfy a court beyond reasonable doubt of the guilt of the defendant? In some cases where there are lots of charges on a file, you need to take care to make sure that in relation to each and every charge, you can locate or identify the admissible evidence that supports that charge. In my experience in doing this, what I'll do is make notes as I go through so that I can tick off each charge when I'm satisfied that there is evidence in relation to each charge. And sometimes what will happen is it will become clear that there isn't evidence in relation to a particular charge, and that can either be removed from the pro forma, or advice can be sought from the investigating officer about whether there is evidence or whether there could be evidence for that charge. So depending on the outcome of that, the charge can either be taken off the pro forma and not proceeded with at that stage, or with the addition of further evidence, the charge can still proceed. And I should say that for most files that we're dealing with, you'll understand that that process is going to be quite quick. For a simple file that might have 2 or 3 charges on it, it's not difficult or onerous to have a look through the file, have a look at the evidence and see that there's evidence in relation to all of the elements of each charge, and you're happy to authorise the complaint being drafted as it's been written on the complaint pro forma. I need to talk now about the rules to remember in statute. And the starting point for us is always Section 26 of the Justices Act. And I say that because for most of the offences that we're dealing with that aren't crimes, they're going to be governed by Section 26 of the Justices Act in terms of the length of time we have to institute proceedings. And that says that unless some other time is provided, we have 6 months from the time when the matter of complaint arose. So it's important that we check the date of the offence. Depending on what that date is, it may be that we're running very close to time to institute proceedings, and in some cases time may have already expired. Particularly with summons files that you look at, it may be that there's been a delay in reporting it. For various reasons the investigation's been delayed, and by the time the file's received at prosecution, the statute of limitations is at risk of being of expiring, or has expired. Now, where it's expired, the complaint is not going to be valid. So we need to make sure that we do have those complaints filed before the 6-month period of time is up. There's also some exceptions in Section 26 where the matter of complaint may give rise to an indictable offence, and that person's been charged with that indictable offence within 6 months, and that gives us an extension of time to file a complaint. In relation to joint charging, that's often an area that causes difficulties. Section 28 of the Justices Act says that any number of persons who are alleged to be parties within the meaning of Section 73 to the same simple offence, or who are alleged to be parties within the meaning of Section 3 of the Criminal Code to the same indictable offence, may be joined in the same complaint, and the same indictable offence may be joined in the same complaint, and the charges against them may be heard together or separately, notwithstanding that a party to the offence is not included in the complaint or is not amenable to justice. We can jointly charge people on the same complaint where they are going to be parties to the offence within the meaning of Section 73 of the Justices Act or Section 3 of the Criminal Code. So there we're talking about our aiders, enablers, abettors, instigators of an offence, in addition to the principal. It's easy to understand too why we'd want to jointly charge people. We can then have one trial and hopefully only need to call witnesses once to give evidence. We can save court time and public expense, and we can reduce the risk of inconsistent outcomes in separate trials. It's important that where we're making these decisions, that for each separate defendant, we can identify the basis of criminal responsibility for them to be properly jointly charged. So when you're looking at the file and you can see that one defendant has been the principal, in other words, they've done the actual act, they've delivered the blow if it's an assault, or they've taken the property if it's a stealing. For the other defendants who are charging as parties and we're jointly charging, that we can identify what acts or acts they've done that make them a party and justifies them being jointly charged under either Section 73 of the Justices Act or Section 3 of the Criminal Code. And in cases where it's not clear what that person's done to be a party, that we seek further advice before we jointly charge them. Subsection 2 of 28 says that where two or more persons are joined as defendants in the same complaint, whether in respect of the same offence or different offences, the justices may, at any time during the hearing on the application of any of the defendants, direct that the hearing of the complaint against the defendant shall be heard separately from the hearing of the complaint against the other or others of them. So a couple of points about that section. Firstly, we're able to jointly charge on the same complaint with different offences arising out of the same incident. The difficulty that we have from a practical point of view with that is currently our police system doesn't allow us to do that easily. So in practical terms, it's normally the case that where two or more people are charged with offences arising out of the same incident, even though they would be permitted to be jointly charged, we normally charge them separately. The other point to remember is Section 27 of the Youth Justice Act 1997, which says that a youth who is under 15 years may not be jointly charged with an adult. So it's always important to remember when we're considering these joint files to consider if one of them is a youth and under 15 years of age. So I want to deal now with Section 29 of the Justices Act, and this is a really important section in terms of drafting a complaint. It's entitled Only One Matter of Complaint, Procedure if Otherwise. It says a complaint shall be for one matter only, and not for two or more matters except A, in the case of indictable offences where the matters complained of are such that they may be charged in one indictment. And if you have a look at Section 311, subsection 2 of the Code, that provides some rules which are basically very similar to the ones that I'll outline here, which are contained in Section 29. Subsection B says, in other cases, if the matters of complaint are substantially of the same act or omission on the part of the defendant, although amounting in law to two or more offences or two or more matters of complaint, or founded on the same facts, or are or form part of a series of offences or matters of complaint of the same or similar character. So that sets out some really important rules about what charges can go on the same complaint. And the rule is effectively that unless the charges comply with one of the rules in this section, we're bound to put only one charge on the complaint. So the starting point is we can put one charge on the complaint. Then, if the charges substantially relate to the same act or omission on the part of the defendant, although amounting in law to two or more offences or two or more matters of complaint, or they're founded on the same facts or form part of a series of offences, then we're justified in putting those offences on the same complaint. So a couple of easy examples. Where you've picked up a drink driver and alongside the drink driving charge, it becomes clear that the defendant was unlicensed and the car was unregistered and uninsured. It's easy to see how they arise on the same facts and can be put into the one complaint. Similarly, if you have a person who has committed a series of shopliftings or a series of burglaries in a particular area or over a particular time span, that series will justify those charges being put on the same complaint. But in a situation where, to come back to the drink driving example, if you had those charges, the drink driving, the unlicensed, the unregistered, but during that process you became aware that there was an outstanding investigation in relation to a stealing some weeks back for that defendant, and you dealt with that at the same time, that the stealing could not be seen to arise on the same facts as the drink driving matters. So it would be inappropriate in that case to draft a complaint with drink driving, unlicensed, unregistered, uninsured and stealing. The stealing should form a separate complaint or possibly a separate file. Now, subsection 4 says that where on the hearing of a complaint it appears to the justices that the defendant may be prejudiced or embarrassed in his defence because the complaint contains more than one matter of complaint, or that for any other reason it's desirable to direct that one or more of the matters of complaint be heard separately, the justices may order a separate hearing of any matter of complaint. So therein lies the ability for defence counsel or the defendants to complain about the way that the complaint has been drafted. To say, well, I'm not able to properly defend myself because of the way that the complaint's been drafted. There are charges on here that don't comply with the section in the Justices Act, so they're not part of a series or they don't arise on the same facts. And they can ask the court to direct that those charges be heard separately. Subsection 5 says, on the hearing of a complaint that does not comply with subsection 1, the justices shall, on the application of the defendant, require the complainant to choose one matter of complaint on which to proceed, and shall strike out of the complaint all other matters without prejudice to the right of the complainant to lay a fresh complaint against the defendant in respect of any matter so struck out. Or if the defendant does not so apply, the justices shall proceed to hear the evidence and shall determine which matters or matters of complaint, if any, is or are proved, and may convict the defendant accordingly. So in a situation where we start a hearing and the defendant says, well, the complaint's not been drafted properly, the court can direct us to proceed on one of those charges and strike out the remaining charges. Now, if those other charges struck out are subject to a statute of limitations, then we may be in a situation where we're prevented from bringing a fresh complaint in relation to those matters struck out. So you can see in that context how important it is that when we draft the complaint, that we comply with those rules and we make sure that the charges which are on the complaint are appropriate to that complaint and not ones which are liable to be struck out for any of these reasons. The text Ross on Crime has a really helpful chapter dealing with joinder of charges and includes some commentary on things like what founded on the same set of facts and same or similar character mean in law. I've included an excerpt of that on Milo, so I'd encourage you to have a look through that when you're doing the assignment and also when you're thinking about what will or won't be justified on a particular complaint. So I turn now to particulars, and just a couple of comments to start with about particulars on a complaint. This is probably one of the more difficult areas when it comes to drafting complaints. As you're aware, as police officers drafting complaint pro forma documents, a lot of the particulars that you'll put in are simply adding in details on a pro forma document that's already been created. So it's like if you're driving, you need to just put in the street, the car and the day, and that's quite an easy process for you. But in relation to some offences, the particulars required ask us to actually think about what words we're going to use to explain the conduct that we're complaining about. And a good example of that is an assault. So we need to include in the complaint the particulars of how the person has said to be assaulted. So whether they were punched, kicked, where to, how many times, are all matters that we need to think about when we're drafting the complaint. Often we'll see on complaint pro formas for these types of offences, the particulars are drafted to include the consequences of the conduct. And that's not necessary. It's not necessary to prove that as a result of an assault someone received a particular injury, or that they fell over, or that something happened as a result. It's important that we prove the actual conduct, which is the assault, so the punch or the kick or whatever the assault is. Now, Section 30 of the Justice Act talks about the statement of offences. Any complaint, summons, warrant or other document that's laid, issued or made for the purpose of or in connection with proceedings before justices shall be sufficient if it A. describes the matter of complaint with which the defendant is charged or of which he is convicted in ordinary language, avoiding as far as possible the use of technical terms, and without necessarily stating all of the essential elements of the matter of complaint. And B. contains such particulars as will give reasonable information of the nature of the matter complained of. So it's important for us to understand that when we're drafting our complaints, we don't need to use technical language, and it's not always, it's not necessary for us to in every case state the essential elements of the matter of complaint. But it's important that a defendant has sufficient information about the nature of the charge and the particulars of it to enable him or her to enter a plea and to mount a defence to the charge if that's what they want to do. You'll also have seen in the Justice's rules the rules relating to things like description of property in a complaint, description of ownership, description of places, times, matter, act or omission, description of money, description of people, of documents in Rules 8 to 14. And that will give you a good idea of what's required in terms of our drafting of those particulars. And you'll see from those that that bears out the words in Section 30, that what's required is simply ordinary language that allows the defendant to understand the nature of the charge and what's being alleged without us using unnecessary technical terms or language. It's important here that, again, we look at the evidence to determine what the particulars should be. Using simple, clear language that accurately depicts what we say has happened without going into too much detail or being so broad that no one is able to understand exactly what's been alleged. So, again, if you consider an example of an assault to the head, depending on what the evidence is and what the complainant can say reliably about what happened to him or her, it may be that the punch was to the nose, but the complainant can't say exactly where on his or her face it happened. So the particulars are adequate by saying a punch to the face or a punch to the head. In that case, the defendant would be able to understand exactly what's being alleged without being so technical to say, well, it was on the left side of the nose or on the ear or on any particular part of the face or head. In some cases, once we've drafted the complaint and filed it, we will receive requests from Defence Counsel for what's called further and better particulars. That indicates that on their assessment of the complaint, further information is required for the defendant to understand the nature of the case against them. Now, our response to that request can be a couple of things. We can either maintain that the complaint is properly drafted, and in that case we'd be having a look at these sections and saying, well, look, we think we've used reasonable language, we think we've explained in sufficient detail what the nature of the charge is and what we say that the defendant has done. But we might also say, well, we understand why the further and better particulars are sought, and then we can have a further look at the case and we can provide some further particulars that we rely on to prove the charge. And to give you an example of that, often when we charge people as parties to a crime, you'll understand that we can charge them as the principal. So the complaint might say that you're charged with stealing a particular item. So reading the complaint, you might think that that person was the principal offender, and that's how the complaint reads. But defence might write and say, well, from the facts or from the evidence, it doesn't appear that you are charging my client as the principal at all, but rather you're saying that that person is a party and that they've done something. So we would ask you to provide further and better particulars of the acts that you rely on as the prosecutor to say that the person is responsible for that crime as a party. So in that case, what we might need to do is go back and have a look and see what the defendant has done, and it might be that they aided the person in some particular way, or enabled the person in some particular way, or instigated the person to commit the offence, and then we will provide them with details saying that in relation to your client, they're charged as a party under Section 3 of the Criminal Code. The acts that we rely on that make them an aider, we say are 1, 2, 3 and 4. So hopefully that explains how we will respond to requests for further and better particulars. Alright, so we're at the stage now where we've got a complaint and we're ready to file it. The most important thing I need to let you know at this stage is that once we've got a complaint that is drafted and signed, the rule is we must lodge the complaint with the court within 7 days. So where a lot of complaints are being drafted at once, and you might be the person who's responsible for checking and signing them, once that's been done, it's important that those complaints are then filed in the court within 7 days for them to be valid. Now, just to finish, I want to make a couple of comments about amending complaints once they've been lodged in court, because in reality, even if we take as much care as we can and are very careful about this process, once a complaint comes into court, it's often the case that we need to make amendments. The starting point is that where there's no statute of limitations, there's generally no difficulty in getting an amendment to a complaint. So for a crime of stealing or burglary, if we need to make an amendment, normally that's something that is easily done in court by making an application. And you'll say, Your Honour, the application is to bring an amendment to count 1 on this complaint, and then you'll take the court to the particulars or the part of the complaint that you want amended. Things become more complicated in 2 respects. Firstly, if we're dealing with a summary charge for which the statute has expired. Once the statute has expired, we're normally stuck with that unless we can persuade the court that there is proper basis to amend the complaint. And Section 31 of the Justices Act deals with irregularities and amendments. It says an objection shall not be taken or allowed to a complaint in respect of an alleged defect therein, in substance or in form, or a variance between it and the evidence in support thereof. But notwithstanding the provisions of that subsection, where a complaint fails to disclose an offence or a matter of complaint, or the defendant appears to have been prejudiced by any defect or variance referred to in that subsection, the Justices shall, unless the complaint is amended as provided in subsection 3, dismiss the complaint. So you can see at that point we are at risk of having a complaint dismissed on the basis that it has a defect that we're unable to fix. Subsection 3 says if it appears to the Justice that the complaint fails to disclose an offence or matter of complaint or is otherwise defective and ought to be amended so as to disclose an offence or matter of complaint or otherwise to cure the defect, the Justices may amend the complaint upon such terms as may be just. So what have the courts said about this? And rather than go into detail about that, I want to refer you to a case which I've put on Milo. It's a recent case of Barnes and Hovington, 2015, Tas Supreme Court 35. That's the most recent judicial decision dealing with the power of courts to amend complaints. And it's a really important case for us as prosecutors to be aware of, to understand the circumstances in which a court will permit us to make an amendment to a complaint that's otherwise out of time according to the statute. So you'll know in a situation where you need to make an amendment to a complaint, whether there is a reasonable prospect of that being permitted. And you can then start to think about the types of amendments that you need to make and at what stage in proceedings. And I should emphasise that as prosecutors we should always be alert to the need to make an amendment to the complaint. So even at early stages in proceedings, if you become aware that there is a defect in the complaint or a problem with it, it's important that we correct that as soon as we can, because once the statute expires, it may be that we're prevented from making that amendment and the complaint becomes hopeless for that reason and is dismissed. The other time when an amendment to a complaint can be more problematic is when the hearing of the complaint has already commenced. Once the hearing has commenced, if we realise that there is an error in the complaint, a claim by a defendant at that stage that he or she has been prejudiced will carry a lot of weight, in the sense that the defendant is defending the complaint that's been brought against them, and for us to be permitted to change that complaint halfway through a hearing that affects the way the defendants prepared their defence may be properly regarded by the court as being prejudicial. So it's really important again that we are aware before we start hearings that the complaint is correct, and prior to the commencement of a hearing make any amendment that we need to, so that a defendant is not prejudiced in this way. Now a defendant might say at the start of a hearing, well, I've come to court today to meet a charge that's now been applied to be amended. But in those circumstances it may be that a court will grant an adjournment, maybe with costs to the defendant, but grant an adjournment to the defendant to allow them the opportunity to meet the changed circumstances. So the reason for mentioning all of that is that it's very important when we are commencing proceedings to take care and try as far as we can to make sure the complaint is drafted according to the rules in the Justices Act and Justices' Rules, but also to be aware that even where we've made a mistake and something is not quite right, that there are rules relating to how we can amend that complaint in court, and subject to those rules we may be able to correct any errors. So to finish, we've covered the process for commencing proceedings, including the importance of file checking and assessment, considering the charges, joint charging, the specific rules for complaints and amendments. It sounds like a lot, and to be honest, sometimes it is. Often you have more than one file to check, and there's obvious time pressures. You'll come to appreciate the value of a high quality investigation for which, when you're checking it, it's easy to see that the charges are appropriate. But to finish, I'd just like to remind you to always seek advice about charges. Even very experienced prosecutors can find it very difficult to decide on exactly the right charges or the right particulars, and so it's always good practice where you're not clear or in two minds about which charges to pursue, to seek some advice before filing the complaint. Thank you.
Thank you. That was